Okay, continuing on now, we are going to deal with Article 1 of the Constitution and how the Jesuits used a provision there to be able in a future day to impose emergency war powers military jurisdiction on all the federal district courts in the country, and that there would be no civilian due process of law, there will only be emergency war powers military due process of law, which is essentially they're going to proceed according to Admiralty jurisprudence, which follows the Roman civil law as objected to by the English Puritans in 1641 with their great remonstrance. Okay, here we have we the people delegated our sovereign legislative power to a Congress. The Congress was composed of the House of Representatives to represent the peoples of each individual states and each area of those states. The House of Representatives represented the people of the state. The Senate represented the states. That's why every state has two senators. Whether it's little old Rhode Island or great big Texas, they only have two senators apiece. Why? Because they're both sovereign nations. They're both sovereign nations in confederation together for certain limited reasons. And so therefore we're not going to give more authority to Pennsylvania than we would to Connecticut. So each state has two senators. See this? This is why senators are never to be directly elected by the people. Never. It was the state governments that were to choose their senators to go to Washington to represent the state government. And the Jesuits undid that with the 17th Amendment in 1913 when they created direct elections for the United States senators that destroyed the state rights of being represented according to the Constitution. So you want to remember, you have the House represented the people, the peoples of the states. You had the Senate to represent the states. Each state has two senators. House of Representatives could be a whole bunch for Texas and one or two for Rhode Island, and rightfully so. Now the other thing you want to remember is all bills are to originate in the House. All bills, all statutes that are going to be passed and made law have to originate in the House of Representatives, not the Senate. The Senate then, once it passes the House, the Senate are composed of older, erudite statesmen who are supposed to have some sort of discernment and quality about themselves and patriotism, so that they will be able to say, well, this particular statute that you brought before us is unconstitutional, so we, the Senate, are not going to pass it. That's how it's supposed to work. NDAA, National Defense Authorization Act, oh, it passes the House, oh great. It should go to the senators and say, no, this is a violation of our right to free speech, and we're not going to pass the NDAA. That's how it's supposed to work. Or the Patriot Act, or any of these other sinful things that they've shoved down our throats for the last many years. So, do you see the beauty in how the Congress is to work? All bills, and by the way, the Jesuits write most of the bills out of Georgetown, and they hand them to their pimps and whores in the House of Representatives to introduce in the Congress so they can pass. Nobody writes anything. That one mulatto congressman out of Illinois that was being interviewed by that Roman Catholic traitor, what's his name? Michael, oh, come on here. Anyway, he's a big liberal, leftist, socialist, communist. Prepared for the priesthood for 1 year, I think. Michael, oh, that'll come to me. Anyway, that congressman said, son, he said, none of us write any of these bills here, and none of us read them for the most part. Yeah. Mm-hmm. So anybody that introduces a bill to be passed and it was not written by him or a committee ought to be taken out and shot. That's how you deal with that. All bills are going to come from representatives of the people, and there's nobody's going to write them up for them and introduce that. The Emergency Banking Relief Act was another one that was written by Meyer and a couple other traders. Every act is to be written by those congressmen. You think they have the ability, after all, most of them are lawyers, don't you think they have the job to sit down and write an act? And by the way, one more thing. No act can be more than 10 pages. Not any 2,500-page Socialist Medicare Act or whatever they passed under the Clinton administration. Didn't get it passed by Clinton, so they passed it under Obamacare. 2,500 pages? You kidding me? There ought to be a law. Only 10 pages per bill. And no writers. Keep it real simple. So, that's how it's supposed to work. You got the House that writes the bills, passes it, the Senate goes, says, okay, we like it, so they pass it, and now they pass the bill and it goes to the president, he signs it into law. Now, if he doesn't like it, he can say, I veto it. That's another check and balance. No president should have ever signed NDAA or the Patriot Act. Nope. So you got a check and balance with the Senate and check and balance with the president. See, the great Andrew Jackson vetoed the act that would continue on the United States Bank. He vetoed it. And rightfully so. 1836, 37, something like that. So we have these wonderful checks and balances to keep from going into absolutism that the Jesuits love. I have one book that says, we're the great absolutists. We don't want our power limited through our trusted third-party representatives. Okay. So, going on here, we have Article 1 with legislative power. In Section 8, you're going to start listing 18 things that Congress can do. Congress can do. Article 1, Section 8. Congress shall have power to regulate commerce, domestic and foreign, blah, 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 blah. And it comes to Clause 11 in Article 1. Congress shall have power to declare war. All the states delegated their war powers as sovereign nation states. They delegated those war powers to the federal government, and rightfully so. You don't want to have a bunch of states that have the right to declare war. It will destroy the Union. So the states gave their war powers, their ability to make war, to the federal government at the time in 1789, because the federal government will become a national government in 1868 with the horrible 14th Amendment put upon us by the radical Red Republicans, specifically John Bingham, who wrote Section 1 of the 14th Amendment, and it was a co-conspirator in covering up the fact the Secretary of War Stanton oversaw the assassination of Lincoln. And you have to get a book called They Wanted Lincoln Dead. Check it up online. Get a copy. It's one of the finest things I've ever read in the Lincoln assassination. So now, the states delegated their power to declare war. Remember that. Remember, the states delegated their power to declare war to the federal government. And after that, the states had no more war powers. No more war powers to exercise. And I'm stressing this because every state court right now sits in an emergency war powers military jurisdiction. How do I know that? Because I was just in court 2 days ago. And what do I see? I see this flag here, which is a war powers court, military government war powers. And I see this particular flag here of the state, which is trimmed in gold fringe with a gold cord and tassels and got a spear on top. A spear is a war flag. It's a military color. In all of our county courts in Pennsylvania here, I just was in the Lebanon County Court, saw courtroom 4, courtroom 2, courtroom 1, where I had to meet a particular business matter. Now stay with me, okay? If the states delegated all their powers to declare war, all their war powers, Do the states have the power to impose an emergency war powers military jurisdiction on their courts? If they delegated those powers to Washington, to the federal government way back in 1789? And if the states had delegated all their war powers back in 1789, and we're sitting in a state war powers flag, this is a military color, then what jurisdiction are all these state courts sitting in? That question, you will never have a judge give you an answer, because it's their secret. It's their great secret that they must keep from all of us enemy belligerents. And you can't know, because you're not part of the brotherhood of the legal brotherhood that went bad in 1936. You're not part of the Masonic Lodge, because most of these courts have Freemasons there, and they know exactly what jurisdiction this is. I went to the Masonic Lodge down in Harrisburg, great big place. Went to the major room where my wife took me for one of my birthdays to see the Nutcracker Suite. And poor ballerina, she fell down. I almost laughed out loud. She was so embarrassed, and she didn't come out to do her final bow. You know, I felt so bad for her. But anyway, on stage there's this flag, military color, and this flag, the military color, at the Masonic Lodge in Harrisburg. They know exactly what it is. It's war. These are war flags. This is military jurisdiction. And so how in the world is a state court sitting in a military jurisdiction unless it's a federal jurisdiction? When I came to this realization, I got goosebumps. I thought, oh my God. Every state court in this country sits in a federal jurisdiction, an emergency war powers military jurisdiction, and it is 50 U.S.C. 4316, the same federal jurisdiction that every federal district court sits in. The exact same jurisdiction. Because the states didn't have power to impose a military jurisdiction in their state courts. They give all their military, they go over their war powers to Congress years ago. They had no power to do that. So it has to come from the federal statute. Do you see the magnitude of this? Now, one more thing. Here's the state constitution. And the state constitution will grant common law and equity to the state courts by way of their constitution. The Jesuits could not overthrow every state constitution. They could not overthrow the common law and equity jurisdiction of the Texas Constitution. Texas has a wonderful provision for equity. So what did they do? Under the guise of emergency war powers, a national banking emergency, state of war, Proclamation 2039, 2040, I'll cover this next, and the Emergency Banking Relief Act, when they then imposed military government, they had to impose a military jurisdiction on all of the federal courts and on the state courts, and it had to be a federal jurisdiction. This is what they did when they decided the Erie decision. The Erie decision does away with federal general common law due process of a civilian due process. It does away with that common law of Article 3, and this particular statute in the Trading with the Enemy Act is waiting to be enacted. It's waiting in the wings to fill the vacuum, and it fills the vacuum so that now every federal court sitting in emergency war powers military jurisdiction by this statute, but so is every state, because no state has the power to confer that kind of jurisdiction because they delegated their war powers to Washington years ago in 1789. With me? I brought this up in the case that I'm in right now, and the president judge of the Lebanon County Court, Judge Tilwalk, didn't say a word. He never objected. I said, I'm bringing this case in exclusive equity of Article 5 of the Pennsylvania State Constitution, I'm not invoking the court's emergency war powers military jurisdiction of 50 U.S.C. 4316. And he never said a word. And the opposing attorney, who's a solicitor for the Prothonotary, Mr. Ian Airgood, never said a word. I name names, right? We got to name names. They know. By the way, when you become the pre-March 9th, 1933 private citizen, they cannot give you an emergency war powers military due process of law in civil or criminal matters. They can go back in the state level. They can do the common law if they want to. And I say great. But the states can't sit at common law, civilian due process, because we're in emergency war powers. We're in a state of war and national banking emergency since March 9th, 1933. So no state court can sit in civilian due process and proceed against you. And when you take my class to become the pre-March 9th, 1933 private citizen, you learn how to invoke civilian due process and your rights, and they can't proceed. The judge must abate, or the moving party must withdraw the action. Other than that, the judge is in breach of his oath, and so is the attorney. They got some serious problems. See how status is everything? When you know your status, you're going to know your right to civilian due process. All that matters for the pre-March 9th, 1933 private citizen is your right to civilian due process of law, period. Because we understand how the court works now. Federal district court, state courts are all sitting in emergency war powers military jurisdiction. You can't do that to me because I'm not an enemy belligerent. I'm not a U.S. citizen, quote unquote. That's an enemy belligerent since March 9th, 1933. If you're going to proceed against me, I have a right to civilian due process protected by Section 1 of the 14th Amendment. The state must give me a due process of law which is civilian, not military. Protected by a Supreme Court case called Hale v. Hinkle, 1906, where the private citizen can conduct his private business, and he can only be proceeded against by the state with a due process of law which is civilian, non-military. Okay, so the states in their constitution, here's the constitution, okay? Constitution of Pennsylvania, whatever, conferred this jurisdiction on all of its state courts. Everybody with me? And they should have done. Wonderful. But when this emergency war powers military, with the Erie decision, 1938, 5 years after the emergency war powers military government's imposed, with the Erie decision of 1938, since they couldn't alter the common law and equity jurisdictions of the states, they overlaid it. They overlaid it with the emergency war powers military jurisdiction from Trading with the Enemy Act, 50 U.S.C. 4316. It overlays it. But it's still there. It's still there to invoke. And there is no judge that will deny you your right to invoke civilian due process, either you're going to go a common law or an equity. He will not deny you that right because he's taken an oath to uphold the Constitution of the state of wherever he's in. Because he knows those jurisdictions are still there, but nobody knows it, and all the lawyers, none of the lawyers use it. They can't. The lawyer must proceed according to emergency war powers military due process, whether it's a civil suit or if he's the district attorney or the attorney general. It's got to be a criminal matter in the emergency war powers. No attorney can proceed in civilian due process of law. Okay? So, what's my point here? My point is that all your federal district courts are sitting in the emergency war powers military due process of law that springs from Article 1, the legislative power of the Congress, when it created Clause 1 down here to Section 8, Clause 11 here, and out of Clause 11, these war powers here that were granted to the Congress, they passed Trading with the Enemy Act on October 6, 1917, after the U.S. entered World War I, and then they put in a little provision in Section 17, for the district court shall have jurisdiction to enforce this act. That's what it says right there in Section 17. It's a new jurisdiction. It's not the old jurisdiction that's listed in Article 3. It's a new jurisdiction proceeding from Article 1. And that's the jurisdiction that's every federal district court sitting in. So it's an Article 3 court, but it's sitting in Article 1 jurisdiction. And it's proceeding according to the course of admiralty jurisprudence. Because every defendant must have a surety. In admiralty jurisprudence, every defendant must have a surety. And for you, you're the man, you're the surety. They're prosecuting the U.S. citizen, the enemy belligerent. And you're viewed as surety until you end that relationship. And now you're not surety, and they can't proceed. All right. So that's training with the Enemy Act, this particular article. State courts are sitting in the same federal jurisdiction that the federal courts are. Can you imagine that? I mean, that's enough for a revolution. How dare you sit in a federal jurisdiction in my beautiful county courthouse here? You punks. Huh? It ought to make men angry. We're not afraid of them. We're angry. And I don't want to be safe. I want to get rid of it. So it's going to take some manhood in in Harrisburg down here to say, we're done with the emergency war powers. And we're not going to be subject to it anymore. And the only way you can do that is you've got to have a Declaration of Independence, because no state legislature can do away with the Trading with the Enemy Act, Emergency Banking Relief Act. And so the only answer is for the state to declare its independence. And this emergency war powers government wants to get us involved in another war in Ukraine, and another war here, and another war there. I'm not sending my sons over there. They're not going. And they shouldn't have to go. But this emergency war powers military government, proceeding with their emergency war powers military jurisdiction, regards you as their property. You're an enemy belligerent. Title has been seized to you as of March 6, 1933, and you're nothing but a serf, but registered property by way of that birth certificate that the commander-in-chief has legal title to it, and they can do anything they want with you under the guise of necessity or emergency, which means drafting your children, sending them to fight in foreign wars so they can come home in a box or cripple for the rest of their life, which is outrageous. So, I've given you all the foundation for what they're doing now, and I'm going to give you one more presentation, then that should be it. So we'll just take a little break, and I'll get this erased and we'll do it.